All right, looks like we're live. Hi, this is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for May 20th of 2024. Brad, go ahead, take us away.
Someday I'm gonna try to figure out how many editions have we done. I know we do about one a week, but at some point we got to have some celebration. 2 years, 3 years. I'm curious.
Yeah, that's a good point. I think I can go back and figure out the total number. But I think we started in December of 2022.
I think that's true.
I think.
That's
So,
true.
and I think we're up to a grand total of $17 in income. So,
Woohoo! That's because we have very many people watching. No, we have a good group, and you're
we do.
watching.
Yeah.
I get emails probably like you do all the time for people saying, "Love watching you, keep it up." We are not doing this for the purpose of getting rich. Let's be fair. But it is a lot of fun to do. I like it. Keeps us relevant and in tune. And I got to tell you, from if any of the people watching are wondering, like, does this stuff really help? Does it matter that we cover? I have to tell you, and I'm doing it today as we speak, my associate Zach sitting, writing a motion to dismiss based on two cases we've had in the last couple of weeks here. And this stuff is real, is relevant. Our comments, we mean what we say, and maybe sometimes, hopefully, we're right. But let's start in the FDNY. This is a great case. It's a great case, not for the reasons that you think I might be saying it. It's an interesting case. It represents yet one more attempt of firefighters nationally to try to get around the prohibition against suing your employer. Last week or a couple weeks ago, we saw somebody say that there is a policy, a Monell type claim, a policy of, that the fire department had of not shutting down dangerous places, something like that.
That's the
And as a
Baltimore
result
case. Yeah.
of, right, and a result of not shutting these homes down or whatever, people went in, got injured.
Mhm.
So this suit is, here are the very simple facts. 4 firefighters severely burned, injured, etc. And of course, obviously our hearts go out to them, but we're on the legal side where we have no heart. And there's a lawsuit against the city by the four separate suits by the 4 firefighters, claiming that the city had a policy, and I want to be clear, had a policy of closing firehouses down temporarily while physical exam day was conducted of the people in the firehouse, right? They closed one firehouse down temporarily, and they said doing so created a significantly heightened risk because we had delayed response times that would allow the fire to grow exponentially, right? It would grow, became more dangerous. It forced another fire engine to violate the vehicle and traffic law by speeding and driving dangerously, so fast because they had to make up for time, and that the city violated some federal laws, even though they don't really say how, violated some federal laws, the fire brigade standard, OSHA, NIOSH safety laws, regulations, rules, etc. But they said as a result of this policy, and you'll see in a minute why I'm being very careful to point this out, as a result of this policy of shutting down the firehouse without backfilling it or taking other precautionary measures, the fire grew, and as a result of the fire growing quickly, these firefighters got injured. Ultimately, it is still trying to sue your employer for injuries on the job. But here's how they try to get around it, right? Again, last week or the week before, we saw someone else try to get around it by saying you had a policy of not doing something that created danger. Here, they said you have a policy of shutting the firehouses down during physicals. So they use a section of statute. There's not a lot of law on this. I have one of the cases that actually is the law on it, case Kyle Pierce versus whoever, where a firefighter was hit by, and I'm going to point this out for a reason, a firefighter was struck while directing traffic and was run over by a pedestrian or by an independent driver, not by his employer. So they didn't face the prohibition of suing your employer. What this law does, the General Municipal Law 105, is it says, and the language is important, that if you violate, you can sue a person, You can sue a person for violating a policy of a municipality. You can sue a person for violating a policy of a municipality. But here, the defendant is a municipality. It's the city of New York. I think this gets thrown out. There's basically two main causes of action, right? And one of them specifically is the city violated a policy. Well, the city isn't a person, and the law is very specific on that. The city is a city, and in the next sentence in 105, they know how to say city, right? And they do. So I don't think you can use 105 the way they're trying it to say, and I have one more. We're going to have a bunch of comments on this.
Is it 205, Brad? Are you referencing 205 or 105?
I'm totally off, isn't it? Oh, it's 205. I'm sorry.
205. Yeah.
Yeah.
205.
So keystroke error. So
that's interesting because I've seen other cases, probably a couple of decades back in FDNY, where they've been using this, and they have used it against, for example, a restaurant owner. When the restaurant owner fails to, for example, have the hood cleaned out, and that in turn leads to a fire, but they don't sue the cook. They don't sue the stockholders.
Corporation.
They sue the corporation.
Well,
so
corporations are people. Municipalities are not.
Is that
I
a New
think
York?
that's how this gets interpreted.
Gotcha.
Moreover, think of the claim. So 205 is for the purpose of suing because you violated a policy. That's not their claim here. The claim here is you adhered to your policy, right?
Interesting.
It's not for violating a policy. The city of New York made a policy, right? We're going to shut down the firehouse. They stuck to it. And so really the claim is you came up with a dangerous policy, which is more of the Monell, the other lawsuit, which I don't think is going to pass muster either. So they recognize clearly here, you can't sue your employer. They're trying to come up with a way, but 205 was not to sue your employer. 205 was to sue somebody with heightened risks of the job. Now, I agree that having longer response times might be heightened risks, but it is almost impossible to win against a municipality, nonetheless one who's your employer, for making a fiscal decision, right? They made a discretionary decision when they created the policy, and they followed the policy. So for so many reasons, again, 205 is for violating a policy. Now, they then use that. That's their first cause of action, their main cause of action. I think it gets thrown out on a motion to dismiss. Look, again, we're talking about the legal issues. I'm not talking about we feel badly for the firefighters.
Or
right?
the rightness or the wrongness of it either.
Right.
We're talking about strictly the legalities of it. And we saw that similar argument in Baltimore where they tried to make it a constitutional issue because they were concerned about either sovereign immunity protection, statutory immunity protection, or workers' comp exclusivity. So that's sort of like the area of protection that municipalities have. I hadn't thought of that interpretation of dissecting it down to the point where we're saying this statute doesn't apply to us because we're not a person under the statute.
And it's only for when you violate a policy, and we didn't. We adhered to our policy. Both to pick either reason. But the next part, they try to wrap it in where they still lose because the city's not a person. And when you look at the statute, they then use a city, right? So they could have said a person or a municipal entity. They didn't. And person means a lot of times corporation, but it also does not mean municipality.
Right. Now, what if there was a federal statute or a federal regulation that they violated?
Well, that's their next cause of action. Their second or third cause of action is exactly that, right? They said you violated a federal policy. But they were very generic. And I can't come up, the 1910 156, the fire brigade standard, I can't come up with one that says anything about response times, right? It's not like they're going to 1720, 1710.
1710, unless they're going to try to throw it in under the general duty requirement that you're required to provide a workplace that's free from recognized hazards.
And that's their last cause of action is the general duty, right? So their last, to your point, right? And it's not going to make a safe place to work and firefighting don't go together, right? And this, again, the normal place in a fire that GML, General Municipal Law 205, would apply to would be, we went into a house, we had this. We went into a house, there was no staircase. We're searching for a fire, and you remove the, you remove the staircase, you remove the banister, so we fell down. That's a heightened risk, right? When you created a dangerous situation and quote unquote invited us in by having a fire. But that's not this. This is a municipality made a reasoned choice, maybe a bad choice, maybe a dangerous choice, but they made a reasoned discretionary choice how they deal with delivering physicals for the safety of firefighters, right? Delivering physicals. And they decided the best and easiest way to do this is to shut down a firehouse at a time. Yes, it may appear like a bad idea, but bad ideas don't win lawsuits.
Interesting.
So that's my take. And again, I don't want anyone to think, right, that Curt and I are coming out against injured firefighters. No. It's just workers' comp is what you get, unfortunately, or fortunately. Right. And, you know, Curt, you went into the history. People think comp is so unfair, you know, or 207A in New York, we get difference between comp and our full benefits, right? You get that up till your retirement age, but you've shared the reason for comp.
Yeah, it really is. It was a social compromise because back in the 1800s, early 1900s, you had workers who were getting hurt. And the law is if you're a worker and in the middle of the day you get hurt, you stop working, you're not going to get paid anymore. That was the traditional rule. And there was no insurance, there was no health care, whatever. You just went off the clock and you were responsible for your own medical bills. So what happened then was that someone who's like, if it was a minor injury, you'd limp home and, you know, eventually you'd come back to work and start getting paid again. But if it was a serious injury where you had medical bills and all that, you had to go to a lawyer and you had to sue your employer. And once you did that, you were not going to get rehired once you were better. Okay, so it put employees in this very bad situation where when they were seriously hurt, they had to sue the employer. Also, employers were getting together and say, hey, don't hire Pinsky or Varone. They'll sue you because they've sued other people. So now it became hard for somebody to get a job again. So it was a bad situation. Also, employers were worried about opening the floodgates of liability to them as well. So what the great social compromise of workers' comp is that the employer had to have insurance, and that insurance had to cover medical and it had to cover lost wages, and it was agreed 2/3, but it was going to be tax-free. So you had the 2/3 of your normal wages plus all your medical bills covered. In exchange for that, you lose the ability to sue your employer, and that also includes coworkers who may have been responsible for creating the injuries that you suffered. Okay. And it was a great social compromise. Makes a lot of sense when you look at it that way. But in a case like this, it seems like, you know, why did the city get away with this? Right. You know, it is what it is.
And ultimately, you know, this lawsuit, turning back to it for a second, the answer wasn't the policy, right? The true harm, and I'm not Monday morning quarterbacking, but they were sent in to a more evolved fire, and the incident commander made a decision to go offensive, not defensive, for whatever reason. I don't know whether there was somebody reported in the house or not. I'm not saying it was a good idea or not, but ultimately it still comes down the last intervening act. That's what they teach in law school. What was the last intervening act or decision that could have prevented or that caused this? And the last one was the IC saying, go offensive, go in. And you know, they made a decision that it was safe enough or there was reason to take that risk. You can say everything that happened before allowed the fire to grow, but so did weather, so did wind, so did rain, so did a million other factors cause the, you know, fire to evolve. They should have had fire sprinkler requirements. I mean, you can say whatever you want, but ultimately the IC standing at the door has the last decision-making ability in or out, defensive, offensive. And they're trying to avoid that discretionary, no way in heck can you ever win on that lawsuit by going back in time saying, well, the IC wouldn't have been in that position. But the IC was in the position. And if it was too dangerous, right, then that's the IC. And even if the IC messed up, there's no way you're winning ever on that lawsuit.
Yeah, and I think that could be one of the, again, some of the counts are kind of, you know, vaguely worded. They could be alleging that the incident commander who is a representative of management, who therefore is a representative of FDNY, was a contributing factor to their injuries, and that the incident commander's negligence, I hate to use that term, but
Alleged negligence.
his decision making was not in accordance with the standard of care, and that therefore the city is, not the incident commander, the city is liable in that way. So again, usually your first complaint is not necessarily your last complaint. You have your first amended complaint, second amended complaint, third amended complaint, and they'll add in. And I am curious about whether or not, if this starts to go the way you suggest, that they might decide to add in those constitutional claims like we saw in Baltimore.
Yeah. I think that has more creativity, more of a chance of winning, but still very hard, because in the end, aren't you really challenging the IC's decision? You may have left it out of the facts, but that was your last chance. And it's the IC who, regardless of anything, made a decision.
Yeah.
And that's what all these claims are for. So, okay, let's go to this one. I don't have as much to say about, honestly. We're going to go to North Carolina, where we have some firefighters alleging that a captain caused them to suffer in a hostile work environment. Ultimately, I think there's a number of people suing here, but saying that he was cantankerous and mean and retaliatory. I read it. I read this complaint. It was very difficult to understand. I want to read a paragraph of it so our viewers have an understanding. It says, the complaint against Captain Moore, the captain whose hostile work environment, included, among other things, demanding, demeaning, condescending, and aggressive behavior towards firefighters of the department, safety concerns around him, undermining firefighters during emergency calls, inappropriate behavior towards EMS personnel, police, rescue, fire instructors, EMS instructors, and other partners, harassment of older, more seasoned members. Now, that's the only one we should be talking about in a moment. Created and enforced rules that he doesn't adhere to, disparate discipline of members based on age. That's the second one that we'll pay attention to, and belittling employees in front of the team. Now, correct me if I'm wrong, but what I've always told people is the phrase hostile work environment is completely misleading. You cannot sue your employer because they're hostile to you, because they're mean, because they yell at you. What you can sue your employer for is treating you differently or hostilely based on your age, sex, gender. Everyone else says, oh, we have a hostile work environment. Our employer's mean to us. That's their right. If you don't like how they treat you, quit. What they can't do.
There is a slight difference, and I agree with you 100% what you said. Some employers have added into their workplace rules a prohibition against creating a hostile work environment. Okay, so but now you're trying to sue your employer for not following the employer's rules, which there's really not a cause of action for that. It might be a grievance in a collective bargaining environment, but it's not, you can't sue your boss because they're not following the rules. Now, if they fire you and you can say that, well, I was righteously complaining about a rule violation, you might be able to qualify as a whistleblower of something of that nature. But
that's
you're absolutely
here.
Right. And there is a lot of misunderstanding about that hostile work environment, that just because your boss yells at you, it does not create a hostile work environment.
Maybe a mean person, but that doesn't mean he's discriminating against you, right? And hostile work environment, so that people understand, is more like I come to work every day and my boss had, tried to grab me or touch me or makes inappropriate sexual comments. And now that I rejected them, I'm being treated unfairly. He's yelling, right? You did something that violated a protected class right? Age, gender. Now here they start off saying at least one of the firefighters is over 40. I don't know if both are, but one is over 40 at least. Right. But when you look at, the reason I pulled out that paragraph is age is mentioned twice, but it's buried in the allegations. It doesn't really seem like because of my age, I treated you differently. And remember, or hostilely, but remember that all they're going to have to do is introduce somebody who's also old and say, well, they don't treat that person differently. Clearly it's not age or just being a jerk. Maybe the boss is a jerk and he treats everybody regardless of age as, that way. But this I don't see this suit surviving based on how it was pled. Now, some courts are very liberal. Well, you said age, you haven't really linked it, but it's pled well enough, we'll let it survive. But I just don't see it here. I got to tell you, this is, if they had something better, it would have been stronger, and it just didn't seem that strong to me.
Mm-hmm.
We should be consultants for people who want to sue others before they sue.
We'll work out. We'll help lawyers with their complaints if in our spare time. But I think they may be able to keep it in under the breach of contract. I don't know how long they'll be able to keep it in on the breach of contract or straight wrongful termination. But and that breach of implied duty of good faith and fair dealing. It's a lot of state by state issues on that. It's not universal. And I'm thinking North Carolina is one of those states where New York, you might stand a pretty good chance of having a judge find that there's an implied duty of good faith and fair deal. And I think North Carolina would probably be one of those states where it'd be hard pressed to find a judge to agree.
No, and look, there's 21 members of this department filed hostile work environment claims. They're missing, and if it's under Title VII type, right, hostile work environment, the fact that there's 21 shows you're not treating anybody differently based on based on sex, gender, age, whatever.
I thought that was interesting. Like, I don't understand how they, like, what category did they file under the EEOC with? One firefighter is claiming age discrimination just because your employer has an officer who is,
over 40,
rather difficult. Well, but the officer is rather difficult. Doesn't give you a claim under the equal protection laws or Title VII. So, and that's the EEOC is really focused on Title VII.
Right.
So I don't know, that kind of raised the question in my mind. But on the other hand, even if you file and unless it's patently fraudulent, filing with the EEOC may give you some sort of protection from retaliation. Now you have a factual question about whether or not it really was retaliation, but
another very tough suit. I would have just joined another department. You got a bad boss, either go to the boss's boss and say, we can't stand them, we're going to leave together. Right? If you got 21 people, to me, I'd be saying all 21 of us collectively, that'll get you some protection, are banding together, and you either get rid of him or her, or, keep us. We'll pick one, but this isn't the way I would handle it. Mm-hmm. Okay, now we have a really interesting one in California, and it's interesting from my perspective, at least. I'm not totally sure. I can guess why you posted it, but because this is one of those things that could really happen to any department. Mm-hmm. We have a claim by an environmental contractor who removes waste and waste oil, and they have to make sure that there's no PCBs in the waste oil. So what they do is they basically get a certification from the fire department saying there's no hazardous materials in our waste oil we're giving you. So they sign it. I don't know what the heck's in waste oil, right? From a truck or anything.
I'm assuming, oil changes, transmission fluid changes, and those types of things. Yeah.
Right. There shouldn't be PCBs in them.
Shouldn't be, but
they tested them and found it. And then they tested more and found more. And the department, probably unknowingly, but it doesn't matter. This is kind of strict liability as I read it, signed off saying there isn't any. Well, there is some. They caught it. And now they're suing for $341,000 some odd dollars, probably because that's their cost to dispose of this, or any fines or penalties, because they had to properly dispose of it. And it's expensive to do that and remediate. My suggestion, any lawyer's suggestion, before you sign something because, and say, I certify that, you darn well better know, or don't sign it. Just say, I have no idea what's in this stuff. Somebody put it in our truck.
Yeah,
and we took it out.
And I'm thinking if you do that, your monthly charge for service is going to go up. Okay, but here's how I kind of read it. And again, we're all a victim of our upbringing and where we brought up. But I know our our repair shop at Providence, they used to do a lot of the routine types of stuff, oil changes, transmission fluid, brakes, and all that. So they would periodically have this kind of stuff accumulate, and they they got to get rid of it. And getting rid of even that kind of waste it's expensive. But when you start getting into PCBs, it's way more expensive. Okay. And it's not uncommon for mechanics to work other jobs. And if a mechanic works, and I'm not saying that's what's happening here, but if you have a mechanic that has a buddy or is working part-time someplace else, and there's a 55-gallon drum of PCB containing material, and it's going to cost $8,000 to get rid of it, and you can bring it to work maybe a little bit at a time and put it in your work stuff, and it's just going to go, and you think nobody's going to find out, and now all of a sudden now you've contaminated the work product. You've got I don't know, that was what kind of came across my thinking when I was reading this. I'm saying, I wonder if someone, and it might not have been a mechanic, might have been somebody else who had access to wherever they store this stuff, but just found it convenient to get rid of it. And, maybe they took a tipping fee in the process. So.
And you raise a great point. We don't know. Look, with the FDNY, Chicago, Detroit, big cities with their big garages.
And this is a big fire department.
Yeah.
San Bernardino County, they are, I believe, the largest county or one of the largest counties in the United States.
Wow.
So they're bigger than my state.
Right.
Which
well,
is
everything's bigger than your state, right?
Yeah. I know you guys have islands bigger than our state, but
true. But not prettier. So, but they could conceivably, as you said, mix oil with somebody else's oil, so you don't know what's going in it. So, right. And as you said, probably not in the big cities where they have their own garages, but think of this if you're a small volley department who does your own oil changes, right? And other members are allowed to do oil changes. You better be real careful about how you dispose of this stuff. So I think this case is interesting for the small department who's getting rid of this oil. If you're and a lot of places do their in-house oil changes and put it in a barrel and roll it out, you better be darn sure that nobody's adding to your oil or anything you're disposing of. And God forbid, because I have this claim a couple of years ago where they're letting it go down the sewer drain. They're washing their cars and they're also pouring some stuff out, old fluids, down the drain. You better not do that. That's in the millions of dollars of cleanup, tens of millions, not hundreds of thousands.
Folks were doing that back in the 70s. People were doing that. Yeah, absolutely. Did a lot of training on hazmat and worked closely with our state DEM hazmat guys. Really terrific guys. But they had investigated folks that would, again, it cost you $8,000 to get rid of a 55-gallon drum. You give it to Bruno, and Bruno put it in the back of a stake body truck. He'd take a can opener and punch holes in it on a rainy day and drive down I-95, and it's coming off you can't tell, is it rain, is it whatever? And then, people
you seem very knowledgeable about the way to dispose of this stuff,
I can't talk about client confidences, but but seriously, but then you have hundreds of people saying, hey, the paint's peeling off my car. I wonder why the paint's peeling off my car.
Yeah. Right.
So
anyway. Where you get an Aaron Brockovich situation, right? Where they're disposing it in the wastewater and it's spreading out because of the retention pond. But there's a lot of this. Look, we put AFFF down the drain how many times? We only got a little left.
I hate to say, we used to use AFFF to scrub the floor because we were told it was soap. It was really nothing more than soap. And once it's, beyond 10 years old, it should be replaced so you can use it as soap. So we'd do our scrub outs with it,
Scares the hell out of me.
Crazy.
Okay. Quickly jumping to Georgia. This you really got to watch, and I watched it. You got to watch the video, but we've got a Georgia fire chief. He was terminated, and now we have he says he's terminated for one reason. The employer said another, right? The employer said you were bullying and disrespecting city officials. Now, that may very well be true, by the way. I didn't see him saying, I never spoke meanly to someone. His interview was basically that he was actually fired for speaking up about staffing and budgeting concerns. Well, speaking up about them doesn't mean you're not speaking too loudly, disrespectfully, whatever. So look, when you work for somebody, you work for somebody. And when they say that's the answer, whether you like it or not, you got two choices: enforce the answer or get out. If you choose to protest, you're putting your job at risk. And I don't know, obviously, but I seem to suspect that somewhere in the middle of this, like most things, is the truth that he really was speaking up about budgeting and staffing, but maybe not in a way that was conducive to not getting terminated.
Yeah, I think there's things you can say in certain parts of the country, and there's parts of the country where you can't say the same thing, you know. And if you're in certainly as a chief, you're an at-will employee,
Right.
and you know you've got to keep your bosses happy when you're in that position. So
Right.
I think as lawyers, we know that. I think coming through the ranks as firefighters, you think that you make it up to chief, you should be able to pretty much tell your bosses whatever you think. Yeah,
Everyone's got a boss.
yeah,
Right. My
sure.
mother, who was in county government forever, always said to me, everybody's got a boss, right? And if you're the top person, you still got a boss. You got the taxpayers or a council, or everybody's got a boss. But it does raise a good leadership issue for those who want to talk about leadership discussions, is what do you do when your employer says something to you that the rank and file aren't going to like? You've got to carry out their bad policy, which isn't your policy. But if you go and badmouth your employer, and I always say this, if you badmouth your employer, why can't people badmouth you? You set the example, right? And look, you could say, I'm enforcing this and that's what I'm going to do. They can badmouth you all you want because people are ignorant. They don't understand what happened above you. But it's not up to you, the leader, to explain to the people below you why you have to follow this, I don't think, and why you disagree. I think your answer is, I follow it because I'm told to, and that's what we're going to do.
Yeah. I mean, I always thought from a leadership perspective, and I followed this through pretty much through, it's almost like an attorney-client relationship where behind closed doors we'll argue and I will advocate for what I think is the right thing to do. Out there, I'm your guy and we argue, you know, we do what we're required to do.
Right.
But behind closed doors, we will debate it and I'll make my point known. And then at the end of the day, you're the boss. We do it the way you want it.
Right. Right. And hopefully your boss listens to you, but you can't just, well, I don't know what they did, but like I said, I suppose somewhere in the middle, there's the boss didn't like how they were being talked to, maybe legitimate concerns.
And I think that's right. I think that's, so it'll be interesting. I think he's going to be filing a suit. So we'll be looking for this one coming, but I thought it was.
Yeah. And I don't think it would be a good suit.
Yeah. Yeah. Well, if he can come up with some sort of a whistleblower, ground, then maybe he'll have some legs, but.
Yeah, that is tough though. Right. And it's got to be a violation of the law, not, something, but okay. So let's go to Nashville to finish up. This is of all the bad suits. I think this is like bad suit day is what we've covered, but now we have obviously a good suit, because good suit, but not good suit for the reason you point out, which I really like what you did. And so I'll give the basic facts, but you got to put your spin on it because something's missing. So a jury, this is a trial. So juries, they're unpredictable at best. And in Nashville, Tennessee, a federal court jury, right? There are juries both in state and federal court sometimes, said that a deputy fire marshal had to be paid $250,000 because she was the victim, they determined, of gender, race, and age discrimination. Now, the proof, and this is such thin proof, but it's a jury, right, who gets to determine whether it's fact or not. That's a fact question. Juries get to do this. But the proof that went in, and I wonder, you got to talk about it, did you find something that maybe wasn't before the jury? But the proof that went in was that there was a male who was hired who had less experience on the job than she did, and there was, I presume, no other reason not to hire her. So since they weren't equal, since she allegedly had more experience, the jury must have found that the employer discriminated by hiring a less qualified male. But then enter Curt Verone.
Yeah, I like the problem here. What kind of draws my attention to it? I know Nashville. I've been down there, and I've got some good friends that are in that department. She's a civilian. Okay, she was hired as a fire investigator, not as a firefighter. So she did not come through the ranks of the fire department. She was an investigator. She eventually got a position which was called a deputy fire marshal, which again, she's not a firefighter. And historically, the fire marshal has been a firefighter. So it's kind of, I don't want to, I don't know how to say this without being demeaning, but you can be the janitor of a school for 40 years. It doesn't qualify you to be the principal.
Right.
Okay. And so she was again a civilian, and now it comes time to promote. And they did consider her. It wasn't that they just didn't consider her, but her lawsuit says that a guy who was hired in 2020 with no experience, who she had to train, he's got no experience, she had to train, got the promotion. It looks like slam dunk race discrimination or gender discrimination. Okay. Well, it turns out he's actually an experienced fire captain.
Right. And that
And
matters to the fire
from what I
service.
understand, a good, solid leader who's respected.
Right.
Okay. So now, well, why did you leave that out of your complaint? You just sort of trivialized that, ignored that. So that's what kind
Well,
of
they did
concerned.
left it out of the complaint because they're good lawyers, right? They left out the bad stuff and said, well, you put in the bad stuff.
I guess, but at the end of the day, no, and you know what? You tip your hat. The jury said no, even though that all came out in trial, we still think that she should have gotten the position, and it was because of her gender. And she did a hidden microphone trap on the fire chief, who is, he's a squared away guy, and he's a good guy. And why he said what he did, when you have to give somebody bad news, you might tend to say things, and I think what he said, he was recorded without his knowledge, saying that they wanted to go with someone younger. And I think that's unfortunate. Now, whether that was really the case or whether it was not, whether he didn't want to say what I said, that you're a
Right.
civilian,
Right.
and this is that we consider the fire marshal be a uniformed firefighter position, and we want to stay with a uniformed firefighter.
Right.
Whether that played a role in it, I don't know. But what concerned me was the presentation in the media that they promoted someone who had absolutely no qualifications, and that he was so unqualified that she had to train that person. Yeah, he's been a firefighter, and now he's going to be doing fire marshal stuff. So yeah, obviously he needs to be brought up to speed on how you operate in the fire marshal's office, but he's been a firefighter all his career.
And the lesson, I think, that when people are writing job descriptions, because people write job descriptions without an understanding of what happens with them. If you write a job description that doesn't create preferences, right? Preferences to somebody with a master's degree, preferences to somebody with actual fire experience. If you don't put that in, it doesn't exist. So when you open the door to a non-fire background candidate, because you did, and you don't create preferences among applicants, preferences with somebody with X experience or background, then there are no preferences, right? And this is what you're going to face. But if you know you're going to have people with experiences that's going to matter to you, I think when you write these job descriptions, you should really put preference too, right? And this is going to be weighted heavier. Tell people up front so that you don't, because without that, you're going to lose these types of things.
And I just going to what you're saying, if you're going to give a preference to having served in the fire marshal's office over somebody who served in a line position, then say that. But otherwise, you can't really say that somebody who's been a firefighter for 20 or 25 or 30 years has no experience. That's disingenuous.
Right.
Now, they may not have been experienced in the fire marshal's office, but they've been a firefighter.
Yeah. Yeah.
So,
I agree.
That's my concern, and the sneakiness involved in, recording the fire chief.
Who's just trying to be nice and say something. It's so unfair. You're not under oath. You're not being deposed. You're just trying to break some bad news to somebody or temper, right? It's they don't always give you the true, honest answer. You're being diplomatic. To hold that against somebody is really.
And I think the jury saw through the race part of this. The fire chief is African American as well, so the jury saw through the race part. They didn't hold up, at least from what I saw, they didn't hold race discrimination, but they did say that there was, I believe it was gender.
Age. It was age, gender. I think it was
yeah. Well, Yeah, no, I think at least according to the news media, like a jury verdict, unless you actually see the verdict form, you don't know for
Right.
sure. But the news media said it was liable for gender discrimination. So
There you go. Yeah, unfortunately. And, unfortunately for the people who are the defendants, this haunts you, right? Will always haunt you.
yeah.
So, all right, that's our cases for today.
All right. Well, it's a pretty interesting week, and we actually got this one done on time. We actually, I think, the first time in 5 weeks, we actually got it done at 1 o'clock, like we promised people we're going to do. So, but all right. So, well, that is going to do it for another edition of Fire Law Roundup. Brad, thank you again.